Okay, so we're going to get started. So thank you everyone for joining us today for today's workshop, Understanding Your Beneficiary Role. For those of you who don't know me, I'm Veronica Van Nest. I am a Vice President Trust Officer of our resident trust company here, Exeter Trust Company, where I review and administer trusts for clients. And also, I am in the advisory services group here at Manning and Napier with my colleague Margaret Jeffries. We're both wealth management consultants in that group. My background is as an estate planning attorney. So my role within the group is generally to review clients' estate plans, give recommendations, review their beneficiary designations. I don't draft documents anymore. I used to in my prior life, but I don't do that now. My role is basically on the estate planning side to give advice and direction to clients. Margaret, who I've worked with for a number of years now, is a certified financial planner. So she helps our clients in engaging in financial planning as well as estate planning advice, particularly beneficiary designations and making sure those are updated. Margaret and I work very closely with the clients on doing that on an ongoing basis. So before we get started, we wanted to have a few housekeeping items here that we want to cover. If you do have questions, we encourage you to submit those through the chat. On my screen, it's under the More button. You can see the chat there and you can type in any questions. We'll try to answer them as we go along, or if you feel free, just raise your hand or turn on your mic and ask questions as we go along. We're happy to answer them. So since you're all here to kind of understand the beneficiary designations and what to do when you're a beneficiary, this is a great group. We have a smaller group here, which is what we wanted, so everybody can feel free to engage. And then you did receive yesterday with the reminder email, you received some worksheets. One is a beneficiary worksheet, which Margaret will be going through a little bit later. You also received a sheet that has a lot of definitions that we'll also be talking through. So with that, we're going to get started. We have the main topics we're going to cover. We're going to kind of divide this into two sections, which the first part being, getting your beneficiary designations in order, making sure those are complete. And the second part of it being what happens if you are actually named as a beneficiary and what you have to do there. So I think I'm going to turn over to Margaret here, who's going to lead us off.
Yeah, so thanks, Veronica, for all the intro. And I do love seeing people on the camera. It makes me happy, so feel free. So I think to kick us off, one of the biggest questions that we get from clients is kind of what is probate and what does that actually mean? Like what assets go under it and what don't. So to kick us off, we actually have this little trivia question, I guess, which should have just popped up on your screen saying, which of the following is an example of probate property? And if you don't know what probate is yet, don't worry. It's on the definition sheet and Veronica's gonna go over it. But from your options of a probate property, A, an IRA with your child listed as the beneficiary, B, a brokerage account with joint ownership, C, a trust that names a charity as a beneficiary, D, a savings account with no beneficiary named, or E, B, and D. So just select which answer you guys think is an example of a probate property. And I did kind of mention the worksheets. Those are also going to be dropped into the chat in case you didn't save them off yesterday. But we're going to be using a lot of lingo in this, during this call, this discussion. So don't worry, we did try to to give you a little bit of definitions there, so that you can follow along. And with that, I'll give just a few more seconds here for the poll. All right, and I think we can cut off the poll there. All right. Wow, we got a smart group here. The correct answer, it was D, a savings account with no beneficiary named, and almost everybody did answer that. So good job, everybody. And with that, I'm going to turn it back over to Veronica to kind of go over more specifically.
Yeah, and the reason we let off with that question is because it's really important to know what type of assets we're talking about with beneficiary designations, what type of assets might pass under your will. So I always like to start the discussion with clients in looking at their estate plan as how assets are titled. Do you have beneficiary designations on those to really see, okay, what's going to pass under your will? What's going to pass outside of your will? So leading that off is kind of how do you own things? So there's a couple, like three main categories of how individuals own property. There's joint with rights of survivorship, which is what a lot of individuals have with their spouses. A lot of times your real estate, if you're married, would be owned with your spouse in that manner. You might have bank accounts, you might have investment accounts. So those are assets. What joint with rights of survivorship means: one person passes away, the other person inherits the account. There's no probate required. Generally, there's not a lot that needs to be done. Maybe you have to give a death certificate to the entity to change ownership just to your name, but nothing has to really go through the courts with the joint with rights of survivorship ownership. We also have tenancy by the entirety, which is generally a spousal ownership. So you'll see that a lot on married people that have real estate on their deeds. It'll say that they own with tenancy by the entirety because they're a married couple. Same basics as joint with rights of survivorship, passes to the spouse at death with generally no requirement that there be any probate done. We do often, with some of our Florida clients, actually see tenancy by the entirety as an ownership to protect some assets too. So we see a lot of physicians doing having property owned with their spouse, maybe with tenants by the entirety, so that they're able to protect those in case there's any litigation for any malpractice or anything down the road. So those two main categories are non-probate. The one category of ownership that, besides you just owning things in your own name, is tenancy in common. So sometimes you'll see individuals who own property as tenancy in common. You can have that on an investment account, you can have it on real estate, a bank account, however, any type of account you have. So tenants in common says one tenant passes away, that does go through probate. So whatever their interest is in that property goes through the probate process, and the other person still has their interest in the property, but it does split. Sometimes we'll see clients doing this for estate planning purposes. Maybe they don't want to separate out the accounts, but they want to separate out the ownership. So we do see that often in that context. A lot of times you'll see tenants in common with like in partnerships or business entities where two individuals, two partners like own a piece of property and they own it as tenants in common, so that if either of them pass away, their property passes to their heirs and the other individual's interest passes to their heirs as well. So those are the ownership interests. We also look at, if you have a will, will handles your probate assets. It's very important to kind of get these terms taken care of at the outset. So a will only governs your probate assets, and those probate assets are assets that are only in your individual name, not payable to a beneficiary. So that's what your will is going to govern. Some people might have a revocable trust. If there's assets in that trust name, the trust terms will tell us who gets the assets after you pass away. Those revocable trust assets generally don't go through probate. So the only thing really to think about when, people hear the dreaded probate word is really assets in your individual name. So, it's important to keep that in mind. We also see the term memorandum. A lot of times personal property can become an issue, and we'll talk a little bit about that later. But personal property being given to a beneficiary can be an issue from a perspective of dividing it up amongst your beneficiaries, and it can get a little dicey. So sometimes people have a memorandum which says, I want my china cabinet to go to Margaret, and I want my dresser to go to Karen. So, people can separate out those things. With personal property, besides like the car, the boat, the ATV, things like that actually have titles, that personal property is pretty easy to kind of transfer amongst everybody. And technically, you're not going to see the probate court get involved in the distribution of that property. And then we have the beneficiary forms, which we're going to talk a lot about today in great detail. And then also irrevocable trusts, which are non-probate. So those are distributed based on the terms of the trust and do not have to go through the probate courts. So with that background, Margaret's going to start with a beneficiary designation or a beneficiary worksheet to kind of get you started on planning.
Okay, but first, I'm really big on polls, guys. So there's gonna be a few. There's gonna be a couple right now back to back. So one poll is how many people actually know with 100% certainty how all of their accounts are titled or owned. So that it's jointly owned, that it's in a revocable trust. And Shay, I think there was gonna be a queue up here for one of the polls, just for everybody to say yes or no. So, well, I can skip to this one. So my second question was gonna be, do you know all of your beneficiaries on all of your accounts? Meaning, do you know who all of your accounts are actually gonna go to? So it could be via the trust. It could be via beneficiary forms. Like, do you actually know how it's gonna flow after your death? So just a quick yes or no to this. Yes, and that is the typical answer that I see from clients, and Veronica gets from clients as well. And I hate to say it, but when Veronica and I first meet with people, it's like maybe I've seen one person that actually has everything in order and it all flows to where they think it's going to flow to. And so today I just wanted to go through this flow chart that we sent out ahead of time, because I think it's a lot better for people to visually think about where their I guess, sorry, little technical difficulties here, just sharing my screen. To really think through, okay, where do you want your assets to go to? And can you guys see that, my screen?
Yes.
Perfect. So the first thing that, we usually ask people is, who do you want your beneficiaries to be? And it sounds like a really easy question, but, people don't really think it through all the way. So do you want your kids, like your family? Do you want any friends to get a little bit? Do you want any charities to share in your estate? And if so, which charities? So I think the biggest thing is like making a list of all the people and entities that you actually want to receive assets, and what happens if that person is no longer around. Like, what do you want to happen if, God forbid, a beneficiary passes away before you? And so usually we suggest making a list, and then I like putting it into flowcharts like this so that we can actually walk through how it's going to trickle down. And when kind of thinking about how it's going to trickle down, there's a couple important definitions that I think people need to understand. And that's going to be per stirpes and per capita. And I'm just going to draw some lines here to kind of show you what each of those actually mean. So say you're a married couple up here, and you have your two children. You have Anne and you have Ross Jr. You want them to just get half and half of the assets. That's a very easy thing to accomplish. You just name the kids as beneficiaries, right? As equal 50% beneficiaries. But what happens next, and going back to, you need to know how you want things to flow. should God forbid something happen to Anne or to Ross, this is where that per stirpes and per capita comes in. So right now the assets just go, okay, 50-50 to Anne and to Ross. But unfortunately, if something were to happen to, say, Anne, and I was joking in our practices that I feel bad just crossing out Anne, but here's what's going to happen. So the difference between per capita and per stirpes is with per capita, everything just flows at the same blue layer. So with Anne passing away, this means that Ross actually gets 100% instead of 50. Right? Even though Anne has 2 children of her own, those children would get nothing under a per capita distribution scheme. And it's actually per capita is typically the default under documents. So if you don't specifically say that you don't want this to happen, if you don't want Ross Jr. to get 100% of the assets, then you need to take an extra step. And that extra step is naming them per stirpes beneficiaries. And per stirpes actually means like by the branch, which I think is very helpful here. So here we still have, want 50% to go to each of the kids. But now with a per stirpes designation, if something were to happen to Anne, this portion now bypasses her and goes straight to the kids. So it follows along the branch, and her 2 kids now get her 50% share, and they would share equally in that. So they would each get, excuse me, handwriting, 25 and 25. And Ross would still get his 50% with per stirpes designations. And I wanted to do that visually, even though it looks like a little bit of a mess here, because it is so hard for us to explain that to clients sometimes in just words. But it is a very important concept. And I think most people generally do intend to name their beneficiaries as per stirpes beneficiaries, but it's completely overlooked in the documents. And that's why at the beginning of this section, I said like, oh, Veronica and I have almost never seen somebody perfectly in order with knowing how stuff is going to flow. And it's because of this per stirpes designation. Some custodians, for example, their forms, and I'm just going to stop sharing my screen here. However I do that. Their forms don't even by default have a per stirpes like checkbox or something for you to do it automatically. Exeter Trust Company, who Veronica, works with, and we work with as a company, it's our sister company. Their form does have that lovely little per stirpes checkbox, but it was only added, I don't know, maybe like 5 or 6 years ago.
Yep.
So if you signed your beneficiary forms before that, chances are they're not in good order. So definitely double check those forms. Other custodians like Schwab, you have to specifically request a special separate form that's not included in the application to specifically add per stirpes. So I do suggest, like, if you haven't laid eyes on your beneficiaries in a while, I would actually, I highly encourage you to do that. Make sure everyone is per stirpes if that's your intent. The other thing that we see a lot with these beneficiary forms and flow downs is like, you don't think about, hey, do we want to leave stuff if God forbid Anne passed away? Do we want to help out her spouse at all? So it's not your blood family who's married in, it's your in-laws, right? But if you don't specifically name for the spouse of a child, then they won't get anything, which could be your intention. But if they're raising, kids, or, you really, really enjoy their company, like you consider them part of the family, you can also include your in-laws specifically, like with clauses in your trust saying, oh, I want, X percentage to go into a trust for my child's spouse, as long as they were still married to my child at the time of my passing and all of that. So there is a lot of flexibility on how you can name your beneficiaries and how you can control what would happen should something happen to one of your beneficiaries before you pass away. So again, circling back to, I think it's very important for you to actually list out who do you want your beneficiaries to be and what would you want to happen. And then we got to make sure all the documents actually match those intentions, which is where Veronica and I come in and say like, okay, it's doing that, or okay, it's not doing that. So, and the other consideration here is that if you have, younger children, they might have, really young children themselves. So if something did happen, then, and you wanted their share to go to their kids, this means, a minor child, someone very young might have some assets coming in. So I know Veronica was going to kind of talk about considerations for that.
Yeah, so it's really important if you are naming minors, or even if, as Margaret said, that per stirpes designation could potentially go to a minor. A couple of considerations that you want to think about is, does your will say if, any minor beneficiaries receive a share of my estate, it's held in trust until a certain age. Sometimes it's 21, sometimes it's 25, sometimes it's longer than that. So you will want to direct that that grandchild's share to that trust as opposed to an outright share. Because with an outright share, and this circumstance just came up, as I said, I do work with a trust company here, and we're the custodian of a lot of accounts for Manning and Napier. And we just had yesterday, I had a conversation with one of our account administrators because she's administering an account and there are 11 beneficiaries. It's not a large account. There's 11 beneficiaries and 4 of them are minors. So what happens in that circumstance is, and I'm a New York attorney, so I can speak to, how the process is here in New York. The parents have to actually petition the local surrogates court to be named as guardian of the property for that minor child. The court then becomes a co-signer on any distributions from those accounts with the parent. And that account is governed until the minor is 18 in New York. Different states vary as far as the age of majority. Most states are 18, some states might be 21. But you have the court's involvement there, where that could have been circumvented had you named a trust for that minor beneficiary as the recipient of that account, as opposed to the minor themselves. So unfortunately, in the circumstance we have with the 4 minor beneficiaries, it's going to involve some work to on the parent side to collect that money, and it's not a huge amount. So but a minor can't sign for themselves. A minor can't sign any documents that are legally binding. So we need to have a parent sign, and just having the parent sign is generally not sufficient. So something to really keep in mind, because it happens. Unfortunately, children can die unexpectedly at young ages, and they might have younger children. So it can become an issue. So it's something to keep in mind if you think that minors could potentially be a recipient of any of your assets.
Yeah, and I also want to point out that usually if a minor becomes a beneficiary, that usually means that your own child has passed away and that their spouse, or ex-spouse would be the one, their new guardian, if you will, would be the one to actually take over the financials. So naming a trust also allows you to name a different trustee if you didn't want that to be the situation. So exactly. And I do that quite a bit, actually.
Yeah, and I think so at this point, I think we're going to kind of, if anybody has any questions, because we're going to switch gears and talk about when you're a beneficiary of of assets. So if you have any questions on how to structure beneficiary designations, if you either want to unmute and ask them or put them in the chat, we're happy to, address those. Otherwise, we can move on to the next section.
What happens if I don't have a will or name beneficiaries on my accounts?
The state where you pass away decides how your beneficiaries are. The state decides who gets your estate. So in New York, and it depends on the states, but in New York, the spouse doesn't get everything. If you have children, not even minor children, if you have children, the spouse gets, I believe, and it's been a while since I looked at the statute, but I believe it's 50,000 plus half of this estate, and the children split the rest. And if there's minor children, again, you can be involved in a situation where the court's involved in that distribution. So if you're not married, and say you're not married, you don't have siblings, your parents are deceased, happens. Your aunts and uncles, and then your cousins are going to get, it might not be the people you want. So it's always important to have a plan in place, whether that plan is everything has a beneficiary designation, which some people, that's their plan, is everything has a beneficiary designation. It's either a beneficiary designation on a retirement account, it's a transfer on death account, it's a payable on death account for a bank account. That's their plan, is everything's going to go by beneficiary designation. I'm not going to have a will, or I'm not going to have assets that are subject to a will, or you have a will, or you have both in conjunction with each other, or a trust, or however you want to do it. But you don't have a say in how things are distributed.
Thanks.
And it can really also complicate things for IRA accounts, because the last thing you want is for an estate to end up as beneficiary of an IRA and for it to miss its opportunity to actually be paid out to individual beneficiaries. Because we have some new rules, which I'm going to go over a little bit later, for IRAs, but something that hasn't changed is that estates only have 5 years to withdraw IRA balances. They don't even have like life expectancy or 10 years, which I'm going to touch on later. But so that's like the last thing you want, is to not name beneficiaries on an IRA. So I see people put a placeholder beneficiary on an IRA or a retirement account when they first set it up, usually a spouse. But then if the spouse passes away before them, there's no beneficiary anymore technically. So it would just go to default to the estate at that point. So yes, it's very, it would also be bad even for just an estate, even if you do have a will, to not name a beneficiary on an IRA.
Thanks.
Does a state's law regarding like the distribution to the spouse, does that override the will?
No, that's only if you have, well, there's a couple of different things, and I'm speaking to New York here. It does not. So if your will says everything goes to my spouse, everything goes to your spouse. However, if your will says, 15% goes to my spouse and everything else goes to my kids, New York state law says every spouse has the right to file what we call a right of election, which allows you to get at least a third of the estate. Plus there's other assets that are figured in there. So to answer your question specifically, what I spoke about before is if the will doesn't say anything, you don't have a will. Or then if you leave your spouse less than that 1/3, New York state will say, not so fast. You have to at least leave your spouse a third, unless they've signed off on it. And there's some ways they can sign off on it, either through a prenup or some type of waiver of the right of election, which is you see those a lot with second marriage situations. You see those documents.
Thank you.
Yep.
And speaking of second marriages, if you do get a divorce, remember to update your beneficiaries.
Exactly.
I have had to pay out assets to ex-spouses before, and there's nothing less enjoyable or whatever as being like, I suggested that after you got the divorce and you didn't follow through, this is what happened. So the kids were very bent out of shape and there was nothing legally we could do about it. So make sure to update those forms.
Yep. Okay, I think we're gonna do the next poll here, right, Margaret?
So we were just curious, out of everyone here, how many people have actually have been themselves a beneficiary of an estate or are expected to be one in the near future? And this is leading into our next section, which is talking about, okay, if you yourself are the beneficiary receiving the assets, what do you need to think about and be concerned about or issues to think through? I think we can wrap it up and see the answer here. So, all right. So mostly everybody here is a beneficiary or is expected to be one, which, I mean, in your lifetime, you would expect that, hope. Not everybody does get an inheritance, but that you are going to have to deal with a parent's passing or something along those lines. So, we wanted to kind of just go over high level, first of all, what are the tax consequences to you as the beneficiary receiving the assets, or what happens at death? The first big topic, which I feel like most people know about or have heard about, is a step up in cost basis. So when someone passes away and leaves a house or a taxable account, a brokerage account, something like that, where you bought it for a price, down here, and now it's worth up here, this usually if you sold it yourself, you're going to be taxed on this difference in that increase in value. With a step up in cost basis at somebody's death, the government says like, okay, well, you don't have to price it down here anymore. You can have it jump up to here. And now there would be no gains to be taxed at death. And so this is a big estate planning tool, I guess, that we would use or make people aware of, is make sure you actually claim that step up in basis. So we obviously, if someone passes away, like we ask them, hey, we're stepping this up, right? There's nothing we don't know about that would prevent that. And we make sure to do it on our system. But some custodians may not do that automatically. It does usually cost a little bit of a fee, to calculate what the new cost should be. That's very standard. You can either have your CPA do it or have the company themselves do it. With real estate, this is really important, I think, because I feel like that's the most overlooked one out of my clients, because you actually have to go in and record this new basis, but it's a house. How do I do that? So there's a process and just kind of reevaluating it and getting that appraised and the cost basis stepped up. And so again, that's assets that were like taxable accounts, taxable brokerage accounts, real estate, if you have collectibles or something along those lines. So anything that was owned in your name, whether it's in trust, in revocable trust or not, it does get that step up in basis. There's no need to step up an IRA because it's an IRA. It's either pre-tax or it isn't. So you don't really need to worry about those retirement accounts with the step up. And I did want to just share an example of how kind of you can mismanage a step up or miss out on getting a step up. I was helping with a situation where I was brought in after the fact where a friend of mine unfortunately lost both of her parents. And I'd found out that a few months before their passing, they'd actually transferred the deed of the house to my friend and to her brother. And this house was like highly appreciated, up and coming neighborhood when they bought it, 20 years ago. And they just transferred it into their own name while they were still alive. So upon them passing, there was no step up in basis because they'd already transferred ownership. And when you do a lifetime gift, you just carry over that basis to the kids. So they completely missed out on getting that free, no taxes on the gain situation. So there is some planning you can do. You know, we see clients all the time with like a highly appreciated stocks or something that they want to sell but don't want to pay the gains. And in those circumstances, it may make sense to just hold on to them, get the step up at death. So it definitely a discussion to have, like, both as a beneficiary and as the one leaving assets, to have within the family. You know, it's kind of one of those like, okay, things are coming up, like, how do we want to handle this?
Yeah, and just with the real estate, so with the real estate, had they, in Margaret's example, had they actually just reserved what we call a life estate for the parent, they would have gotten that step up. That's a life use of the parent. The parent still pays all the taxes, pays the upkeep, still retains any exemptions they might have on the property, like a veteran's exemption. We see those quite often, or a senior exemption. They still retain that, but when they pass away, the kids actually get that step up in basis. And we see this done a lot in Medicaid planning. A lot of times, you'll gift real estate to children, retaining a life estate for the parents. And it really does help with that, the step up issue that Margaret's saying, because a lot of times, real estate is one of the biggest appreciators over time.
Definitely. And the next kind of issue that we talk about with our clients, like tax-wise, is IRA balances or retirement account balances that you're going to inherit from a loved one, or a friend. The new Secure Act, well, I guess it's been 3 years now. I shouldn't call it new anymore. The Secure Act has really changed things for beneficiaries of IRAs. If you're not a spouse or if you're not a minor child of the IRA owner, or you could be a friend that's within 10 years of age of the deceased, or if you're older than them in general. If you don't fall into one of those categories, you now have to withdraw the IRA balance within 10 years of them passing away, of you receiving that inherited IRA balance. And obviously for some of us, that are still working, this could have a really big impact on our own situation. So right now with that legislation, you kind of have the flexibility to decide how to withdraw those IRA balances, inherited IRA balances, within those 10 years. So you can get with your CPA and manage it a little bit. And just to backtrack, IRA balances that you inherit, if it's a traditional IRA, that's going to be taxable to you. Any withdrawals that come out is going to be ordinary income to you, unless there was like a little bit of after-tax basis, which would be reported to you, when they passed away. Roth IRA balances that you inherit are still completely tax-free to you. So no withdrawals that come out, you don't have to pay taxes on them. You do have to still take it out within 10 years, but it's not really like a tax consideration. It's more, do I want to like get more growth in there? Do I actually need to spend the money? That kind of discussion. Traditional IRA assets, pre-tax IRA assets, that's going to be more, how do I manage my income for the next 10 years? Because if you inherit, $1 million IRA, that's $100,000 of additional income every year. Or you just take it in year 10, and that's $1 million of income in year 10. So it's a big thing to consider when you're inheriting those IRA assets. There is one pending legislation that we've been seeing for the past 2 years. It keeps getting delayed, where during those 10 years, the beneficiary still has to take lifetime required minimum distributions for just those 10 years. So spouses, they take those lifetime distributions actually over their lifetime. So not within 10 years, it's just for however long they remain alive. But using the same exact calculations, these other beneficiaries will have to take required minimum distributions for those 10 years. But that has not passed yet. Everyone keeps talking about it like it has, but it actually has not. So we are obviously keeping an eye on it, and would let everyone know if that changed. And I do want to point out that this is for IRAs inherited after 2020 in or after 2020. So if you have an inherited IRA already, this doesn't really, that was inherited before that, this doesn't really apply. You're still going to take those smaller amounts each year. It's not as big of a consideration, but these newer inherited IRAs are going to be a lot bigger of a consideration for people. And I know we haven't really talked about life insurance yet. So just quickly touching on life insurance, death benefits that you receive from life insurance are tax-free to the beneficiary, which is obviously great for the beneficiary. It only the deceased might have to pay some like estate taxes or something on it, but in terms of you receiving it as a beneficiary, you're not going to have to pay taxes on that balance that comes to you. And that would also include any outstanding loans would have to come out of that balance first, but you don't, unlike something like an annuity or something like that, you don't have to pay taxes on any outstanding loan balances either. That just comes out of the death benefit ahead of time, and then you get the rest. So, and for those beneficiaries that do have situations where they already have a ton of assets, they don't want, you know, a bunch of IRA assets negatively impacting their income each year, you know, because they're getting great deductions or something like that. There is something allowed called a disclaimer of assets. So basically you can say, I don't want it. You know, like someone name me as their beneficiary in their trust or will or beneficiary form, but you don't want it. You can go through the disclaimer process. And I think Veronica, you were going to go over that, kind of how that works.
Yeah, so it's especially important if you think that that's something that might happen in the future to make sure that those beneficiary designations are in order, to make sure that there's like that per stirpes that, you know, Margaret spoke about earlier, or there's someone that would inherit if you don't. So disclaimers are, we use them as ways to sometimes fix an estate plan. Or we also use them as ways to, you know, you do have a successful child who says, you know what, I want my kids to get it. I don't really need it. So those disclaimers are done. They have to be done within 9 months of death. It's a document that's, there's a couple of different documents that encompass it, but it's basically the individual saying, I don't want this. And because I don't want this, this is where it goes. It's not deemed a gift of the person disclaiming. It has to, the person disclaiming can't direct it. It just goes by whatever the terms of the beneficiary designation of the will say. So for example, you know, Margaret leaves something to me per stirpes, and I say, you know what, I don't need it. I want it to go to my kids. I sign disclaimer documents. I get those to the custodian of the account within 9 months, and then it just goes to my kids, and my kids then inherit what would have otherwise been my share. I've not made a gift to my children, and it's a nice way to kind of, if you don't need the assets, to pass them on to children. We see, you know, older adults who have, you know, children in their 20s, and maybe they don't need it from their parents who, you know, are in their 80s or 90s who have passed away, and they're allowing their children to start a nest egg to, you know, purchase the home or do something like that. So they are a great tool to use. And, you know, we see them often, we see them in estate planning too, to kind of create trusts and things, but really in this context, it's really just to create, to allow that second generation to receive those assets. And then I think, Margaret, I was going to then go on to talk about like what happens when you're a beneficiary. Who do you contact?
Yeah, who needs to do what? Who's actually the one that's going to reach out to all these people and do stuff?
Yeah, so I think, often we get, Margaret and I work with our, a lot of clients, and we do, financial planning for them. We do estate planning for them. We create these nice reports for them. And so oftentimes, something happens and they might come to us and say, okay, where do I go? What do I do? Um, so it's important to kind of know what everybody's role is. So one of the things, and Margaret and I have talked about this over the years, is personal property. What happens if you're left personal property in the will? So the will says all the personal property is divided amongst the kids as equally as possible by the executor. So the executor is responsible for doing that. Now, I've had the situation as an estate planning attorney before I came here to Manning and Napier, where we had an estate. I think there were 8 siblings, didn't quite get along with each other. And we had to have an estate sale, and then we had a lottery, and they got to agree on, the fake Hummel that was, $10 valued by the estate appraiser. Actually, no, it's only, I'm only going to pay 5 for it. And we had to kind of do that. So tangible personal property, in my experience, is the biggest fight in any estate. So, some things to keep in mind with that is, sometimes give people things ahead of time, or just kind of have a list and say, this is what I want to go where. But that is the executor's job. The executor is going to gather the assets. That includes the tangible personal property. The executor is going to collect bank accounts in the individual's name. They're going to collect any investment accounts in the individual's name. So they're going to take care of collecting those accounts and setting up an estate account and then distributing them out to beneficiaries. That's only accounts in the individual's name. So that's what the executor is responsible for. The executor is responsible for paying bills, making distributions, paying income taxes, paying any estate taxes that are due, and making distributions to the beneficiaries. Now, one of the questions we get is, well, how long should I expect it to take to receive what I'm due from an estate? And speaking to New York has a 7-month creditor period after the filing of probate. So for 7 months after the time of probate is filed, the executor generally shouldn't distribute, because that executor is going to be personally liable for any distributions they make if any creditors come back and say, you owe me money. Now you say, oh, that probably doesn't happen. It did. It happened in an estate that I was administering, where we had an executor who was very much, my mom had no debts. I'm going to make these distributions. I want to make them now. Okay. Against our advice, he did. And lo and behold, within the 7-month creditor period, there were some nursing home bills that were unpaid, and the creditor came forward. And so the executor had to then go to his siblings and say, give me X amount of money back because I need to pay these bills. So it's important to understand that most estates are, and most distributions from an estate are probably, I would say, within a year, you're getting the assets. You might get a portion of the assets, say 6 months, 7 months. But usually within a year, unless there's any big complications, or unless there's the filing of an estate tax return that's due. But generally you would get it in that time frame. So that's your probate assets. Your non-probate assets, you can get those really quickly. So non-probate assets are, the IRAs that we've been talking a lot about. Those IRAs, generally you give a death certificate to the custodian of the account, and you provide them with a tax ID number. You provide them where you want the money to go, and you can set up a new inherited IRA. Usually that can be done a month or 2 after death. It's not super complicated.
Yeah, that's the beneficiary that does that. It's not the executor. It's the one actually named on the beneficiary form.
Yeah, and so sometimes the question is, well, how do I know? Sometimes you might not know. Some custodians, and we do this, is generally, if we're aware of a death, if, a child of the decedent sends in a death certificate, we know that there's a death, we will send, we generally send out letters to the beneficiaries and say, you know, you've been named as a beneficiary and let us know what you want to do. So, but every custodian may not do that. And so
Or
you
not have the contact information of the people, so.
exactly. So sometimes we're stuck with the executor kind of telling us what to do, but but those assets you can generally collect pretty quickly. Life insurance is the same way. Life insurance, you generally just produce the death certificate and they will send you a check. It's generally pretty easy. You usually have some claim forms to fill out. With trust, the trustee just continues, there's no probate required, so the trustee just continues administering the trust, and they might make those distributions rather quickly too, depending on the terms of the trust, but the trustee is responsible for that. And then, you know, real estate can get complicated. We have, you know, you might have a situation where, say you have everything going by beneficiary designation to your beneficiaries, but you still have a piece of real estate. Well, who's going to pay for the expenses of that real estate? Who's going to pay the taxes? Who's going to pay the upkeep? If it's a vacation home, does everybody want that vacation home? So there's a lot of things with real estate that can get somewhat complicated. You know, is it going to have to be sold? Are there going to need to be repairs done with it? So I think it's important to think about where you want that real estate to go. And generally we see those vacation homes being more of an issue than the individual's residence. But think about that, because your executor is going to control that unless there's some deed done ahead of time. But those are kind of the basics. Anything I missed, Margaret, or anything you wanted to touch on?
No, I think you pretty much covered it. It's, yeah, I think you pretty much covered it. But you talking about the vacation homes, I think brings up something else we wanted to touch on real quick. I know we're about to run out of time here. Is that we think it's really important for beneficiaries and whoever's leaving them the assets to have discussions about what should, you know, going back to, okay, I don't need the money, so don't name me, you know. Don't wait for do the disclaimer, you know, communicate ahead of time, you know, hey, I don't really need the money, just leave it to my own kids or leave it to my siblings, you know, however you need that to happen. The vacation home that you brought up, that's so important. I don't know how many times I've seen, well, I don't want to deal with the vacation house. I don't want anything to deal with it. Just give me my share. When another sibling's like, oh, I do want the vacation home, so I'll buy you out. But, you know, if you just talked about it ahead of time, then the will could have said, I leave the vacation home to, you know, this one child, and I leave an extra XYZ dollars to this other kid. And it'll make the process, the payout process and change of title way easier, way faster, with less fighting among families. So and that's kind of one of our big goals here is like, you know, we try to help mediate for the family, so that we can be the bad guy, not the family members among themselves.
Yeah, and I think, go ahead, Margaret, sorry.
Oh, no, I was.
No, I think that, you know, one thing, you know, to leave you with is that, you know, really understanding what all of your assets are, and also checking, as Margaret, you know, and I have kind of stressed today, double checking those beneficiary designations, making sure that per stirpes is there if that's how you want it. Making sure, you know, that there's no deceased beneficiaries still on those designations, things like that, I think is super important.
Right, yep, and that per stirpes, it's such a simple phrase, but we see it missing from wills and trust documents all the time too. It's not just beneficiary forms, it's within your actual documents themselves. So for our clients, we try to flag that, but like someone that's not looking for it probably wouldn't notice that it's missing. Because again, the default is to just keep it on the same level of beneficiaries, so among siblings, but you want it to go down to the grandkids, for example. So if you don't know to look for it, you won't know what's missing. So just give those documents an additional read. And I guess there's no last minute questions here. All right, so now that we're coming up in the end, I just wanted to thank you guys all again for attending. If you have any additional questions, please reach out to us. We are a resource to help make sure that your estate plan is how you actually want it to be. Again, we read through documents, we review the beneficiary designations themselves. We don't, no offense, people, we don't rely on what you tell us you think is happening. We read the documents themselves to see what's actually happening. So please feel free to schedule a call with me, Veronica, make sure your plan, beneficiaries are all up to date. And behalf of both of us and Manning and Napier, thank you again for taking the time to attend our special workshop on the role beneficiaries play in distributing assets and wealth. We hope you have a wonderful rest of your day. And it was nice to see the one camera. Thank you. I really appreciate you.
Thank you, everyone.